All right, I guess it's 11:15, and welcome to Bar Talk, April 3rd, 2020. Welcome, everyone. One of the things we wanted to do is just touch base on what emergency orders have come out to date. I don't think there's been any change since since yesterday, related to both the judiciary and or the notarization order we were expecting out of the governor. We are going to try to reserve some time today for the Board of Overseers. 5 minutes is our goal with them. And Angela, was there anything more we wanted to say about orders, or can I skip to business?
If you could just give a quick update on where we stand with the notarization, because I have received a couple of questions by email that for people who haven't been on this call before.
Sure. So last week, I think it was March 25th, the MSBA took the lead in sending a letter with actually some proposed language for an order, essentially lifting the requirements of in-person contact with persons for notarization and acknowledgement pursuant to notary rules in Title IV. And that was later followed up by the Probate and Trust Advisory Commission, the Maine Bankers Association, and the Realtors Association, Realtor Development Association, on Monday this week. So things have been moving fast. We got a call from the governor's office this week asking us to opine on the proposed order that was actually fashioned and drafted by members of those three groups. And we concurred on 99% of what they had. And last we heard yesterday, it was in the AG's office being reviewed, and we think we're going to hear something imminently on being able to do notarizations via video. I want to move on to business issues. So again, I can't focus enough on communication. If you want to keep your law practice being relevant for your clients, you need to continually stay in touch with them, okay, about what's going on. Everyone's kind of nervous, anxious about those things. About the SBA, the Paycheck Protection Program, I believe, is launched effective today. I even was on a conference, a video Zoom chat with Stan Tupper and his gang out of the Portland area, and we had a person indicate they had already made the application. You should be getting in touch with the bank that you work with and go from there. All right. So we have I think we either have Aria E on the line or Justin Andrus.
You've got both of us.
All right. So we've got the Reps Bar Council from the Board of Overseers. Thank you, Aria, for being on today. And we look forward to your visits in the future. Can you tell us about can you tell us about what's been happening that you're seeing for trends?
Sure. So one of the things that has been coming up a fair amount in questions to us is whether or not attorneys are still essential legal services, whether we can stay open under the governor's recent orders. And so I've continued to answer that. Justin's answered that question. You can stay open, and you should if you're able to, just like Thad said. Right now is really the time for you to be reassuring your clients that you're available to them. And we sent out an email blast last week or earlier this week regarding a lot of ethical considerations during this time period. We want you to know we've got your back, just like we said in that blast. And our ethics helpline is available. So please call us at 623-1121. And email's great as well. We're in the office on a skeletal work crew and in and out of the office remotely as well. Then before I turn it over to Justin about a particularly hot topic on our ethics helpline. Just want to also say another emerging issue has to deal with lawyers and their concerns about clients who may have a presumptive diagnosis of COVID-19 or a positive test, and whether or not the attorney can make any disclosures around that to protect public safety. So on the attorney side of that, it implicates Rule 1.6. And again, please call us with those questions because they're very fact specific. Thad, thanks for the update on the notary issue. We're still getting calls about that. And primary burgeoning issue right now is lawyers either being terminated or furloughed. And so we're getting calls mostly from those lawyers. And since Justin has been taking those calls in the last couple of days, I'm going to turn it over to him for specifics related to our opinion, the Professional Ethics Commission Opinion 219. Go ahead, Justin.
Good morning, everybody. Thank you. Before I launch into that, I just want to say that we are available to answer ethics line type questions outside of the hours that have traditionally been available. There's a lot going on, so one of us may need to call you back, but you don't necessarily have to wait until the windows that have been historically available to reach out to us. We want to help you navigate the process as best we can. We have been getting a lot of calls from attorneys. It looks like, are you able to hear me? Okay. It looks like, there was an interruption here. It looks like a lot of firms are releasing associates in an effort to manage their cash flow. And before I launch back into how to handle that, if that's what you need to do, we would ask everybody to act deliberately. It's your business to run, it's your business to operate in all respects. But this is a time for deliberate, considered action, not for being reactionary. So consider through what you need to do. But we are getting indications from associates that they are being asked to surrender their keys, take their stuff and go almost immediately, sometimes truly immediately, and that firms are engaging in conduct that is problematic in terms of efforts to retain clients. So we just want to remind everybody that the client absolutely has the right to choose who will serve that client when an associate or partner leaves the firm. The client needs to be given the choice, not only if the departing attorney is attorney of record and the person principally responsible for the case, but also if that attorney has had significant client contact, even if they are not what the firm considers the primary or the originating attorney. There is written guidance at Opinion 219, and if you find yourself in a situation, or if you find yourself advising another attorney about how to handle the situation where they're going to let somebody go, you should look to that. The client needs to be notified and informed of their options. The client needs to be given that choice in a neutral way. The firm and the departing attorney both are restricted from communicating in a way that's designed to limit client options or drive them in one direction or the other. We've seen indications that firms believe that they have the sole prerogative to communicate. It is important to note that it is the responsible attorney's responsibility to make that communication. So the departing attorney must participate in that communication. We're seeing things about people having to get files. Please remember that your departing attorneys have the right to have the file. And if they're going to be responsible for the client after their departure, they have the right to have the original file. The issues coming up with respect to fee deposits. The fee deposit belongs to the client and goes with the client. The firm who has been terminated, if the client chooses to go with the departing associate, should return the money to the client unless the client provides written guidance otherwise. So there's a lot of stuff there. I'm sure most of you know that. We've been hammering on lateral transfers over the last year because we've been seeing a lot of them before it. But we've seen a very dramatic uptick in those, and want to make sure that while everybody runs their business as they see fit, that they're protecting their client interests. And so there you go. If you have questions about how to do that precisely, call me and we will walk you through it. At the end of this call, it's some of the earlier calls, people have stayed on. I've noticed that. To the extent that it's okay with the bar, I will stay on if there are questions and can address them.
Thank you, Justin. So we have just a few minutes. I wanted to go to the next item on our slide, which is the personal side updates. So I've been continuing with what Bill Nugent had recommended is determining gratitude, and I'm grateful for our bar membership. And that's what I journaled. And it showed again this morning about just sharing it with Stan Tupper's 7 o'clock session this morning. Our bar members are more than willing to help out, share information, and I'm pretty proud of that.
Thanks for the shout out, Thad, for MAP.
Oh, you're welcome, Bill. And then the other part that I wanted to mention as far as hydration. Remember I said that there are 6 things related to staying healthy, and you saw Bar Council in their blast mention staying healthy is really an ethical consideration. The 6 things that I had mentioned before were sleep, exercise, diet, hydration, relationships, and work tempo. Regarding hydration, the rule of thumb out there is that you should drink enough water to equal about half your body weight in ounces, okay? So going to questions that we've received and forwarded to the communications director, Amy Quinlan, as well as to Chief Softly. We had some ones come in yesterday that were related to how the courts are handling requests for emergency orders related to child contact issues. So that seems to be an issue up in the Penobscot County region, and we're trying to see what we can do to help with clarifying how the judiciary is going to handle those type of requests. I also wanted to comment, we have been getting daily requests for some clarification on the rule related to the expansion of filing timeline, especially related to notices of appeal. And there was a specific question we forwarded, piggybacking on top of that earlier this week, related to how Rule 59 motions fit into notices of appeal also. So we've got just a couple minutes where there are questions or chat that persons wanted to share or concerns during these couple of minutes before we're done at 11:30.
Thad, I had a question about some probate orders, and I wanted to let everybody on the call know that we have received a few more, and they can be found right on our COVID-19 page. You'll see down here, we now have added Kennebec County and Saginaw County right here.
I see that.
And also there's for family law attorneys, if you're willing to spend some time volunteering at Free Legal Answers, VLP could use your help. And you can register here. And finally, if you haven't been able to join us on previous bar talks, but would like to see what was discussed, we have those right here. View previous bar talks, and it's a link right here, and it will take you to our YouTube channel.
Thank you, Angela. And
Thanks.
just to reiterate, we keep these bar talks to 15 minutes or less. It's an effort just to make sure that we can do this every day to touch base with our membership and provide a forum for sending questions via email and or expressing them orally. I'm hoping that we're going to be able to get Bar Council from the Board of Overseers to join us at least every Friday. So, you know, please stay tuned, and any other things that you think we should be addressing on this broadcast, let us know.
Hey, Tad, could I ask a question, Tad?
Yep. Yep. Go ahead.
Alan Shepard, and I sent an email to Angela just a short while ago, and it was concerning the thing that you mentioned about the notice of appeal. Do you have any sense that there's going to be a response, or do you think that we're going to be left with just having to interpret that March 30th order as best we can?
I do think we're going to get a response. Alan, we have been told by the communications director, Amy Quinlan, that, and by Justice Softly, that they're putting together essentially in a question answer format responses to all the questions that are being forwarded to them. So, and I was told on Monday from Amy Quinlan that she expected to get a product out by the end of the week. So it could be imminent.
We still got time. Angela, is my question any different than one that was posed before? I don't need to belabor it. I'm sorry I missed the chat you guys had when this issue came up.
No, it was very similar to the other questions we've been receiving. So like I
Great.
said, we've forwarded that on.
Excellent. Thank you, guys.
All right, you got it. All right, we're signing off, and we will leave this open for 2 minutes if there's something you want to address with Justin. Thanks.
Thanks, Dad.
Thank you.